Good morning. Hello, everyone, and welcome. We're excited to have you with us today for our webinar. My name is Julie Ludwig, Marketing Communications Specialist here at Church and Casualty. And today we're going to talk about AB506, Part 1. We talked about what the bill is and analyzing the bill. And in Part 2 today, we'll go over recommendations and specific guidance on how youth service organizations and houses of worship can comply. So I'm joined by our partner, Ministry Safe, and our presenter and host today, Gregory Love, who I will introduce in just a moment. But first, wanted to go over two quick housekeeping items before we begin. First, we'll be sending this webinar recording out via email, so be sure to look out for that. And second, we will have no Q&A today, but if you do have any questions, feel free to email us directly and we'll do our best to get those answered for you. So our presenter, Gregory Love, is the managing partner at the law firm of Love and Norris, also the co-founder of Ministry Safe and Abuse Prevention Systems. His clients include denominations, churches, universities, private schools, public and private charities, and youth sports groups. He's an expert in legal standards of care related to child sexual abuse. He has consulted with organizations like the U.S. Olympic Committee, U.S. Center for Safe Sport, Awana International, Trail Life USA, U.S. Youth Soccer, North American Mission Board, and other faith-based organizations and denominations. He is visiting faculty at Dallas Theological Seminary, where he teaches the only graduate level course on preventing sexual abuse in ministry contexts. And he regularly provides instruction and continuing education training to lawyers and risk management professionals. So with that, I will go ahead and hand it over to Gregory.
Great. Thanks, Julie. I'm happy to be here again. And I'm kind of happy to be partnering with Church and Casualty to try to discuss this, to try to help navigate this. I'm not excited about the fact that we have a piece of legislation that it takes multiple webinars to try to navigate and understand. But in this part 2, I'm going to try to touch on some of the things that we've already covered that lead us into some of the questions that we now know that people are struggling to navigate. So I wanted to point out again, just as Julie mentioned, there are some existing resources. So I know there's hundreds of people that are attending this webinar, and some of you, this is the first time that you're joining us in trying to untangle this. So if you went to ministrysafe.com/CCIA, or go to ccia.com/AB506. There's a number of ways in which you can get to a place where you can access the white paper that we've written about this new legislation, even a video discussion about this, what she referenced as Part 1. In that landing page, you'll also find the supporting pieces of legislation that help make AB 506 make sense, because that legislation makes reference to other sections of California law that help you understand what it's saying. So in other words, it's not a standalone piece that makes sense all within its four corners. But then there's also a growing list of FAQs that you can find on our site, on CCIA's site, because chances are if you have a question, other people are asking those questions as well. And some of those questions are difficult to answer in simply a paragraph, because there's a sub part of the question, or once you get this answer, it's like, wait a minute, that leads me then to ask you this. So there's a limitation of what we can provide in those FAQs, but you'll find those helpful. What we're going to do in this part 2 is make some observations again, introducing the law, and then get to a place where some of the things which are now presented as some of the challenges that are starting to be refined for certain organizations, we can unpack those just a little bit. So up at 30,000 feet, we're going to talk about this concept called standard of care. Now, we went in detail as to what is meant by standard of care, but real quickly, standard of care is simply the lawyer term for this is what you should be doing about a foreseeable risk. And for child-serving organizations, child sexual abuse is a foreseeable risk. We don't need any more headlines to be able to bring that to our attention. Okay, so even before AB 506, there was already such a thing as standard of care for all organizations in California and every other state. So if somebody had a program, whether you're a church, camp, school, nonprofit, youth sport organization, there is already an expectation of what is reasonable for you to do to address the foreseeable risk of child sexual abuse. Okay? And that will have included efforts relating to training, screening, background checks, policies and procedures, and a framework to make that effort sustainable. Okay? We call it an effective safety system. At Ministry Safe and Abuse Prevention Systems, we call that a 5-part safety system because it has, wait for it, 5 parts, okay? Nothing magic about that, but it's simply saying all organizations that serve children need to have a framework, an effective safety system, which includes training, screening, criminal background checks, and policies and procedures. AB506 is not something that creates a brand new standard of care. In other words, you're not doing child services and all of a sudden somebody passed legislation in 2021 that wakes you up to the fact that you need to be doing something. AB 506 simply makes some specific requirements as it relates to those elements that all child serving organizations should already have in place. Okay, so if you are not doing anything and everything that I'm going to describe in AB 506 is brand new to you, welcome to child sexual abuse prevention. Okay, you're late to the party. So all of you should have something in place, and your question should be, how does this new California legislation require me to do something different? Do I need to raise a bar? Do I need to add some feature to what I'm already doing? That's what we're going to try to help you answer those particular questions, all right? So another observation that we made in part 1 that I'm going to continue to make now. So for those of you who are looking for some well-crafted, precisioned answers to help you navigate exactly what's required of you, you're going to be disappointed today. Because AB 506 was not a well-crafted piece of legislation, all right? It's not very long. At least we have that going for us, that it's not lengthy. It's just difficult to understand. It creates questions and challenges. All right. So we're going to try to navigate those. Me telling you in advance, some of the answers you're going to get are not going to satisfy you. And frankly, they don't satisfy me or the folks at CCIA either. We're just going to navigate the best we can, and hopefully somebody in the legislature will modify this based upon the struggles that organizations are having that can provide us some clarity and relief consistent with the reality of what we're already trying to do. But with that being said, let's start that adventure. Kind of the questions that AB 506 presents is, who is a youth service organization? Who's impacted by this new law? What the action is required by the new law? And what things, if I'm already having an effective safety system in place, what things is this new legislation requiring me to do different than I'm already doing? How can I comply with that? Now, I'm going to touch on these again with a focus to get us to what are some of the new challenges that have arisen that we can now, with 90 days, 120 days of seeing organizations struggle, what are the natural questions that are coming to our attention, whether it's at the folks at CCIA or in my office? So that's what I want to touch on in the 4 big components of who's required to comply, and then in those subsection breakdowns of the training, background check, and policies and procedures. So here we go. This new section of law, in other words, it's not called AB 506 in the actual legislation. That's just the title it gets when it's going through the process in California. Ultimately, what it's called is Section 18975. That fits within paragraph 2.9 of the Youth Services Organization section of the Business and Professional Code in California. All right, so you can use AB 506, but after a while it will start being referred to as Section 18975, which is going to hit 3 big things related to your standard of care: training, background checks, and policies and procedures. So we're going to take the who before we deal with these individual elements. So some of you are still struggling with the fact that in those requirements for training, background checks, and policies and procedures, it's making requirements of youth service organizations. Okay, it's like, if you're still struggling with, well, is that me? There may be nothing that we're going to provide you today that's going to help you with some precision. Okay, so in that part 1, we talked about the fact that this is a goofy definition, all right? It's a difficult to understand with precision. Am I a youth service organization? Because if you'll notice, the definition is circular. Okay? So the definition that this new legislation gives us is a youth service organization means an organization that's using one of these type of people. So once again, it's referring outside of AB 506 and referencing a type of person within the list of mandatory reporters, of California Penal Code. Okay, so that section 11165.7 is the list of mandated reporters in California. That subparagraph 7 is a particular description of a person within that large list. And that particular subparagraph 7 person is defined as an administrator or employee of a public or private youth center, youth recreation program, or youth organization. Okay, so if we put all of these together, that definition doesn't help us much. In other words, there's somebody in the legislation knew that we needed the definition, but then what they gave us was essentially this. A youth service organization means an organization that uses somebody from a youth organization. Okay. The way that we deal with that is essentially, when in doubt, it's talking to you. If you have a program that serves children or youth, there's a good chance you are a youth service organization. So another way to say that is, you are unless you're not. Now let me explain what I mean by that. All right. Once again, we always interpret legislation related to child protection, child safety in its broadest possible way. All right. In other words, we don't read this definition and try to find a way that it's read narrowly, such that it didn't apply to me. It didn't specifically say our type of program. You read these definitions in such a way as like it's probably talking to me, unless it's specifically not. Now, here's what I mean by that. First of all, my churches, my youth sport organizations, my nonprofits, you need to wake up and understand legislation is now being required. So in other words, these standards of care, these things you already should be doing, now somebody over here is saying, and you need to focus on 1, 2, 3. Now let's focus on what I mean by you are unless you're not. Okay? AB 506 was a very broad, almost like a shotgun approach to making sure that child safety is a priority. So if you get down into the legislative history of this, you'll realize this assemblywoman from San Diego saw a situation unfold with Boy Scouts of America. I mean, they're the headlines. They're very rude. Lots of children, 82,000 something claimants. Okay, it's an extraordinary problem. And seeing this problem, it's like, we have to make sure that never happens again. Sexual abuse, this crisis can't happen again. Therefore, we're going to pass this legislation that's going to make these requirements. Now, in California, there were already entities that had licensure requirement, that had specific standards of care related to child safety that were already implemented, active, and ongoing. Licensed daycares. Education is highly regulated. Okay, so you have some places in California, especially licensed organizations, that already had oversight agencies, oversight committees. They had licensure requirements. They had people regularly coming in to ensure that they're maintaining those minimum standards of care. Okay, so AB 506 went out as if there was a blanket need for child safety legislation, with some of these organizations saying, we're already doing these things, and we're doing them in not just a broad brush type of way. We're already doing them in very specific, licensed, and highly regulated ways. So part of what I mean by you are unless you're not is one of the ways that I'm seeing people navigate this, and we're actually advising people that navigate this. If you're already a licensed organization, and the focus that I have now is on my schools and daycares, you already have oversight entities. I would suggest that you check with your licensing representative and get an opinion from them. They are your primary audience that specifically takes not just general child protection type matters, but they're specifically into your particular type of programming. Get confirmation from them whether or not they expect you to comply with AB 506. Now, with respect to my daycares, for example, they're already doing the background check requirements under AB 506, which is the live scan system. Most of my daycares, it's like they're already doing the mandatory, reporter training. Where my daycares have had questions is on this need to have 2 adults in every classroom. Okay, which is, wait a minute, we can't staff that way, and that's not required by our licensure. So it's normally the policies and procedures that are becoming the questions for my schools and daycares. But as soon as I say that for my schools, for many of you, I'm going to take that back. Because see, a lot of my schools, especially as people start finding alternative forms of education in charter schools, homeschool co-ops, things like that, those aren't necessarily licensed. Okay, so if you are a school and you don't have a licensure oversight body, I would tell you AB 506 is your new requirement. But if you are somebody that has a licensure body, a representative within a government structure that's providing you specific standards of care, check with them and have them confirm for you that, yes, AB 506 is the general for everybody. You're not the general for everybody because you already have your specific requirements. So, same with my youth sport organizations. Now, this is a little trickier because you're not licensed in the state of California, but in a way, there was legislation that was signed in 2018. It was called the Safe Sport Act of 2017, or actually, it's the Safe Sport Authorization Act and Child Abuse Victim. I mean, it has a longer name than that. This is just my reference for it because it's easier to say. But there are some significant requirements with respect to national governing bodies, different sport organizations that are sanctioned by an NGB, okay? And there are specific things that are required by the oversight of the U.S. Center for Safe Sport. Federal legislation made people in youth sport mandated reporters. So if you're a youth sport organization and affiliated with a national governing body, chances are you have a different oversight mechanism. But once again, you'd need somebody to confirm that for you. It's just a challenge when you have an organization that's like, when I already have these very specific requirements that are program specific, and now I have this broad brush requirement that makes these things more difficult for me. Trying to get somebody, though, at the U.S. Center for Safe Sport to confirm that for you will be a challenge. But once again, youth sport organizations, you're dealing with children, you're a youth service organization, there is standards of care, but if you want to seek some kind of a clarification as to whether or not Center for Safe Sport is your guidance as opposed to AB 506, start that adventure now. Now, for everybody else, when in doubt, just understand you're a youth service organization. You should already have standards and care in place. Let's just see what AB 506 does that means that we might have something else that we need to do. So, what action is required? How do I comply? Broken down into 3 big segments: training, background checks, policies. Let's look again at the training piece. All right. So, what it gives us on the training is administrators, employees, or regular volunteers shall train, may use the DSS training. Okay, so you shall training, but you may use this particular training. Okay, here's where a lot of the new questions have arisen. So just as an aside, I hope you're not an organization that's reading this or listening to this and thinking, oh, well, I guess we should start training our people. See, there was a standard of care even before AB 506. You should have already been training your people with a training that helped them understand sexual abuse risk, preferential offender, grooming process of the preferential offender, methods to reduce that risk, impacts of abuse on children, all of the things that are necessary in a sexual abuse awareness training. Okay, so I hope you're already doing that. Okay, if you are, what does this new legislation mean for you? Because here's the new wrinkles in this legislation for my entities that are already doing a sexual abuse awareness training is, you shall complete the training, no problem yet, but your training shall cover child abuse and neglect identification and reporting. Okay, so the first thing I want to point out, your training needs to be more broad than child sexual abuse. It needs to include child abuse. See, that's a more broad term. So child abuse should cover your neglect, emotional abuse, verbal abuse, physical abuse. So your training is going to have to broaden beyond your sexual abuse training, and it needs to cover reporting. Again, your training should already cover reporting, but perhaps you're an organization that's a national organization, and your national organization already has a sexual abuse awareness training. Does that comply? What about the trainings I'm already using that I've received from my denomination, that I've received from my school association? Okay, does it cover sexual abuse? Yes. Does it cover all the other forms of abuse? If the answer is yes, great. Then the next question is, does it cover specific California reporting requirements and processes? If the answer is no, you need to get another segment added to your particular training. So all of that to say, your sexual abuse awareness training, that's now the good start. You need to have the extra piece on the other forms of abuse, we call them maltreatment, and the extra piece on the California specific reporting requirements. All right. So if you already have a training that covers sexual abuse, get those two extra pieces, and then I think you comply with AB506. Because with the state of California, in other words, how I get to that place is you must do a training. Here's an example of a training which satisfies us. And if you went and watched the DSS training, it would cover sexual abuse, those other forms of maltreatment, and specific information related to the California reporting processes and requirements. Okay? So with that being the instruction, the pathway, if you will, that's why I can recommend that we don't necessarily have to use this training. They're telling you, hey, you may use this. It's not very interactive. It's 4 hours long, and it it doesn't integrate with any of your HR systems, your safety systems that you use as an online framework. So there's a lot of reasons not to use this, but I'm here to tell you it's instructive for making sure that the training that we are going to use needs to make sure it hits these elements which are covered in the DSS training. Now, more I want to say about that in just a moment, but let's get to a place where we can talk about what are the questions. You should already be doing the training. How does AB 506 modify this? What are some of the questions that arise? Now, I've had a handful of organizations call me and say, well, Greg, we've been using the ministry safe training. We've been using the abuse prevention systems training, but I saw on this one particular website, or I received communication from another entity that you can either use the DSS training from the state of California or use their training, and they are the only other approved training available to satisfy that requirement. I found that was interesting because I'm here to tell you there is no mechanism in the state of California to submit your training for approval. There's no oversight entity. There's no agency to submit it to. See, in Texas, there's the Texas Department of State Health Services. So in California, because we got this piece of legislation, it was brief, and sometimes brief isn't always best. But nonetheless, it gave us no other instruction other than this one will satisfy us, but you may use other ones, cover these topics. So there really is no approval process in the state of California. So what it means to me is there's really nobody that can stand up and claim, not even administrative safe or abuse prevention systems, that mine is the only training that complies with this new state requirement. In fact, I know several organizations that have called me and said, hey, we have our own training that we've created in-house. Is that going to comply with AB 506? Like, hey, you don't have to use my training, but you need to make sure that you kind of follow my logic in understanding these are the topics that are covered in the DSS training. Make sure your training covers those. So long and the short of it is, there may be many training options, say a year from now, as different organizations want to create that training and make it program specific, entity specific, branded with their particular people. But it's simply going to have people taking the time to do that. At present, the options are that DSS training from the state of California. Certainly there's our training. And I would tell you there may be other trainings. I'm just not familiar with them. But please don't quickly listen to somebody tell you, we have the only thing that's approved, because there really is no such thing in the state of California. All right. Now, another question that we have commonly asked is, will we have to train, and it lists on the law, administrators, employees, and regular volunteers. So Does that mean we have to train all of our volunteers? Because some of our volunteers only work this many hours, and we're not thinking they're going to account to that 32 hours per year or 16 hours a month, however that was drawn out. I would tell you, training people is easy. In fact, training people, in my opinion, is standard of care and necessary. So my recommendation to you is everybody gets trained. There is no harm to everybody understanding child abuse, neglect, and the reporting requirements in the state of California, and there's a lot of benefits to it. And it's not an expensive proposition, for example, maybe like the background check piece. So my suggestion to you is, don't try to play games with this many hours, and I can carve this person's schedule back to make sure they don't have to be in this. When in doubt, train your people, staff members and volunteers. Okay, another question has arisen. I mean, this law has only been in effect for 4 months, but it's already people asking, well, how often do I have to refresh this training? Is this a training I have to renew periodically? Now, again, the legislation didn't give us that. Now, what I would recommend to you is, when in doubt, refresh your training every 2 years. If you have the ability to do it every year. See, again, there's no harm in making sure that people receive training with respect to child protection, sexual abuse, physical abuse, neglect, and reporting requirements. So until there's more definition, I would tell you every 2 years, and if you have the ability, do it every year. So now, what about those people that just finished training? I have a mega church in San Diego that had just finished training. In fact, I flew there and trained live hundreds of people. And now we got this piece of legislation. So we just trained them in sexual abuse awareness, but now the new legislation says you must train them in child abuse and neglect and the reporting requirements. So what do we do about that? Does this all become meaningless now and we need to go and redo a complete training? My recommendation to them and other organizations which are already training is, if it was more than a year ago, I tell you to go ahead and just retrain with the new training that we've done that adds the supplements on maltreatment and the reporting requirements, which complies with AB506 in my opinion. But if you're that entity like the one that I'm referring to, and we just did the sexual abuse awareness training, I would tell you, take the opportunity and give your people the extra pieces that your prior training didn't cover on the other forms of abuse and the reporting requirements, and then calculate their renewal date based upon that time when they got the sexual abuse awareness training. So there's ways to navigate that, but I would tell you that the training that you were doing before doesn't necessarily become meaningless. Now, I hope it's an effective sexual abuse awareness training. If you'd like an example of what I mean by an effective sexual abuse awareness training, I'm happy to provide that. In fact, as a follow-up to this, I'm going to send everybody a sexual abuse awareness training, but not only just sexual abuse, it adds the two California, supplements on the maltreatment and the reporting requirements, so you'll know what I mean by an effective training that complies with AB 506. So if you're already doing the sexual abuse piece and you've looked at ours and realized, maybe my training wasn't effective sexual abuse awareness training, then let's just hit reset, start over, and get them trained. But if your opinion, it's like, yeah, we're doing a pretty good job on the sexual abuse piece, then let me help you add the other pieces involving maltreatment and California reporting requirements, and let's get this thing moving and start setting your refresh dates accordingly. So past trainings, I think they're useful and valuable, but because I don't know what your past trainings are, if they're not mine, I can't opine as to whether or not they're effective sexual abuse trainings, but I think we can put that together and I can give you the ability to have a training that you can lay side by side with yours, and ours is about, even with the extra supplements, about 1 hour and 25 minutes long, as opposed to the 4-hour training from that DSS. Now, last thing I want to say about the trainings is keep your records. Now, even though there's no oversight entity, there's no licensing body to have someone come to your organization with a clipboard to check off your 506 requirements, the way that this is going to become significant is related to your requirements for insurance coverage and if something goes wrong. See, if something goes wrong, that's when the civil trial lawyers pick up standard of care and lay it down on what you were doing to confirm were you complying with the things necessary to protect children? I need for you to keep the record so that you can be able to demonstrate, yes, in fact, we were doing the things necessary on the training, background checks, and policies and procedures. So however you choose to solve this and to create a system to where it can be sustainable and refreshed, keep your records. One of the things I love about our system, see, as a civil trial lawyer, part of the logic that I built into Ministry Safe and that online platform is always having a sensitivity to record preservation, to be able to demonstrate whether someone has met their standards of care. So I don't want to spend the time that we have today in just an hour to try to walk you through the elements of a Ministry Safe safety system, but I can make a short video demo available in the follow-up to this for registrants to help you just understand, when he talks about a framework that makes it sustainable, this is what he meant. So look for that. It'll be following. Now, let's get away from the training and get into the background check pieces. Again, a lot of more information and deeper dives on some of the things. If you're just getting to part 2 and you missed part 1, go to either one of these places and to get that information. Background checks. This is where actually we're getting the most questions, especially from our churches, that as the overarching statement that kicks us off, 30,000 feet, background checks should not be new to you. You should already be doing criminal background checks. And on not just your staff members, but also for your employees. Okay, so standard of care generally, even preceding AB506, was that every child-serving organization must make a reasonable effort to obtain information about a staff member or volunteer's past criminal history, with a high sensitivity on those things that might let you know that this person could be dangerous with children, especially sexual abuse. Now keep in mind, AB506 had the legislator identifying sexual abuse risk as the prime mover that brought AB506 into life. So sexual abuse is what's making the headlines. Sexual abuse allegations are the things which are mission killers. So your standard of care is you should already have some effort to gather a staff member or volunteer's past criminal history specifically related to child sexual abuse. And why I say specifically related to child sexual abuse is AB 506 in many ways, even though the legislature intended to raise the bar, how people read this and react to it could in effect, in my opinion, lower the bar. And that's what I want you to avoid. So it can, once again, it's that section 18975 paragraph B talks about the background checks, and quickly introducing it to us again. An administrator, employer, regular, volunteer, all three, I'm going to come back to that, shall undergo a background check. Now, if the legislation stopped there, that administrators, employees, and volunteers of a youth service organization shall do a background check, period, then there would probably be no problem. People would look at that and go, yep, we're already doing that, keep going. Okay, some people might go, whoa, well, we're not doing background checks on our volunteers, but we can start doing that. I already have a process. I already have a third-party background check vendor that has a dashboard for me to order different levels of searches, national searches, sex offender registries, get other information may be valuable to me, my motor vehicle records, okay? Most of my child-serving organizations already have a vendor relationship, a process for gathering criminal histories that satisfy that requirement of the reasonable search specifically related to child sexual abuse. But see, here's the wrinkle that AB 506 gives us. Now it's not only you shall do a background check, you shall do a particular type of background check. And this particular type of background check is not one that your third-party background check vendor can provide for you. Now, there's plenty of entities, including us, that are trying to figure out ways to make that more simplified for our child-serving organizations in California, but it's a challenge. And it's not only going to be a challenge for us, it's a challenge that many of you are experiencing, and I'm going to get to that in just a second. But first, I want to answer the question quickly. What is this type of search? Okay, it's a 1105.3 search. It's like, what's that? Again, you have to leave AB 506 and get to the different piece of the penal code to understand what in the world is it talking about. Okay, Many of you already know what in the world they're talking about because you may already be doing this penal code search, this 1105.3 search. Okay, let's go there and then let's figure out where are the challenges. See, 1105.3 is not new. It's an already existing legislation that was actually a gift. It's actually a great idea of making available to entities that serve children to have access to the California DOJ records. Okay, recognizing that you may already be doing searches that are going to gather information from other states, sex offender registries, motor vehicle records, and things like that. But the California Department of Justice said, hey, we'll make these records that we have available as well to those people that are supervising and interacting with children. So you may come to us and access these records. But know that if you chose to, there's a certain pathway to be able to gain access to those records. And they get to choose what is the pathway to gain those records. And they chose to do that through a fingerprint matching system reliant upon a system called LiveScan. And I know by now there's no way that you've never heard of that before, because this is one of the biggest challenges, and I'm not going to start walking you again through what is a LiveScan process. I want to get to the better questions that most of my people are struggling with now. Okay, so once again, 1105.3 is an existing access to California DOJ records that up until January 1st were simply made available to child serving organizations if they chose to take advantage of it. Now AB506 says you shall take advantage of it. And you have to do it in the way that is already the way that the DOJ expects people to access those records. And it's not an easy way. It requires fingerprinting. And there is no way to automate a fingerprint. There's no way to get around the fact that somebody's going to have to take a piece of paper, go to a place, have their fingers inked and rolled onto that piece of paper. Lots of the other pieces of that can be simplified, but see, there's no way to get around that particular piece. Certainly not at present. Okay? So with that being said, organizations that are youth service organizations who may have already had a very slick and sophisticated way in which to do that reasonable search for criminal histories now have an added requirement. You shall do this. Okay? Lots more detail that we can walk you through on some of the other challenges, but I want to get to the ones that people are asking about now. Okay, so what are the steps for this? Okay, the first step in this is you have to apply with the California Department of Justice to get an ORI number. In other words, the whole point in this, if you have staff members and volunteers, is you now have to do this search. Like, wow. Okay, I already had a vendor relationship and I was already doing reasonable criminal searches. You're telling me I have to do this now too? Now see, a lot of people read that as like, okay, well, this system I was doing, I guess we're done with that. And we'll start doing now what the California legislature tells us what we must do. I'm here to tell you that's where the place that we err. Okay? Because I'm here to advise you we don't wrap up our otherwise reasonable criminal search and start doing exactly what AB 506 tells us to do. In other words, it's not an either or. Your standard of care is to make a reasonable search for past criminal history, especially related to child sexual abuse. Okay, well, how is this California DOJ search different from what I'm doing at present? See, there's some serious limitations to what is in the California Department of Justice records. They're matched by fingerprinting. You're not going to get a match if a record doesn't exist without a fingerprint type of access point. In addition to that, you're not going to get any records outside the state of California. Additionally, you're not going to get any sex offender registries. That information is not contained in the California Department of Justice records. So for you to do that reasonable search, in my opinion, frankly, what you were probably doing before AB 506 was more geared toward identifying someone who might have been a sexual abuser from anywhere else other than in the country and on a sex offender registry than what information might be contained in the California DOJ records. Okay, so what I would tell you is you shall do this if you're a youth service organization in California. You don't get a pass. I'm just here to tell you, don't stop doing this and just do this, because you may be ending your ability to identify records from other parts of the country and sex offender registries to something that then becomes very narrow and doesn't include the sex offender registry. Okay, so I'm hoping that somebody in the legislature in California will start to understand the challenge this presents for child serving organizations and try to modify that, maybe even take that shall out and change it to a may. But until then, my recommendation is we do the reasonable search and we do this as well. Now, doing the AB506 search as well, there are some other practical challenges. You see, the whole goal is if you as an organization have 100 staff members and volunteers, you have to first get your organizational ID number such that when these people do get your particular live scan form and go get their fingerprints rolled wherever and however they do that, and then that form is uploaded through a live scan machine, the results of that then are reported back to the organization. See, nothing gets reported back to you unless the California DOJ has issued you an organization number to know even who you are. There is now a queued up line for organizations in response to this legislation that are trying to get their ORI number. We tried to get an ORI number to start understanding how we can modify and simplify the system for our clients. We applied for our ORI number in very first week in January. It's now late April and we have yet to get our ORI number. So I know hundreds of organizations that have called me and said, hey, we're just in the queue to get an ORI number. We can't possibly even begin to comply with this live scan search until we get the ORI number. Then we can tackle some of the logistical difficulties about rolling fingerprints. And I tell you, I appreciate your problem. So what the California legislature did is they gave you a what without a how. Now, my recommendation to you is go ahead and apply for your ORI number. Get in that queue. In the meantime, we can start figuring out how to struggle through compliance with this while continuing to do our existing background checks, which I hope are deep enough to give you the information which comprise a reasonable search with respect to past criminal histories, focusing specifically on the child sexual abuse piece, which is at a minimum is your sex offender registries. Okay, so we don't get a pass. We have to start the process. Don't put this process down and just focus on this one, because we can get into a ditch that nobody in the California legislature really thought through. Okay, and just an example to explain what I mean by that. Let's take Larry Nassar, for example, of USA Gymnastics fame. Let's say that Larry Nassar, who was convicted in Michigan, magically gets paroled and he wants to come get a job in sunny California. If you did just the California DOJ search on Larry Nassar, you will get none of his conviction records out of Michigan, and you will not be able to understand he's a sex offender on the registry. Okay? You will get just California DOJ records. Okay, so we just need to understand what the California legislature, I don't think, understood in passing this legislation, how child serving organizations will react to this by understanding, well, okay, well, this is my standard of care in California. I can hang up this, and this is my budget. It's only costing me $10, $15 a search, sometimes cheaper. And now I'm going to do this pretty expensive search that gives me less information when the whole point was to protect children from child sexual abuse. Deep cleansing breath. It's a challenge. But my recommendation to you is get started, start figuring out the process, make sure that you're doing both. Okay, so in some of the questions, should the new live scan replace my other searches? I would tell you no. You must get the sex offender registry. You must get that national search, even if it's that multi-jurisdictional database that a lot of entities call a national search. It's not perfect, but at least it's going to give you a broad swath of that information that's outside of the California ORI number. Challenges there, get yourself in the queue. We'll just figure it out as we move forward. Also, for those of you who have your ORI number, but your challenge is how to get people's fingerprints rolled, how to get through the inconvenience of all of your volunteers to have them be troubled by taking a form, even if you're sweet and nice and give them a Krispy Kreme with it, to go somewhere, get their fingers rolled, get it uploaded, pay the fee to get their fingerprints rolled, Because see, you can have the fees waived for the search if you're a nonprofit. You do not get the fees waived to have your person get their fingerprints rolled. What we're seeing is some entities that are being creative and are responding to this, and I call them fingerprinting food trucks. Okay, they don't call themselves that. Okay, but we're starting to meet some organizations, especially in the urban areas, that will actually have a food truck, if you will, with a couple of live scan machines that are portable and will come to your organization. So if you can gather all your people for a cookout and then have the fingerprinting food truck there and try to make it at least low impact for your people or your faculty and staff, you can have at least that element come to you. This one entity that we've had discussions with, federalfingerprinting.com, I'm not in any way endorsing them or recommending them, just to go to their website and get an example of somebody that's actually trying to meet this need in a creative way. Now, a lot of people have also asked, well, if I add the FBI add-on, does that give me the broader search that goes nationwide that I'm not otherwise getting from the California DOJ records? Okay, the answer is kinda, but not really. Because you've got to understand, in that FBI add-on, only 28 states are participating in that particular add-on. So there's still several states and jurisdictions that are not going to be covered by that. So we just got to be good consumers and not try to say, well, then I guess I'm just going to go do this. Be very careful before you leave your existing relationship doing your background checks and doing the reasonable searches for past criminal behavior and thinking that there's just a quick FBI, ooh, that's got to be good information because it's the FBI. Get beyond the labels and do some research to understand exactly what you're getting before you lay this one down or you make modifications, especially those things that significantly impact your budget. Okay? Another question that I've had is like, well, what about the employees that don't work with kids? What if in my program I have my CEOs, my COOs, my people that are administrative, but they don't actually involve themselves in the programming where there are interactivity with children or the opportunity to have the one-on-one interactions or anything like that? I would here tell you the law doesn't give you a pass on this either. And frankly, you shouldn't look for the pass here. Okay, the legislation says administrators, employees, and regular volunteers shall get the training, shall undergo the criminal background check. So when you talk about training and criminal background checks, it's almost like they've created this subset of people in the volunteer category that some of your volunteers may just have such an ancillary impact on children that we could carve them out of these requirements, but there is no such carve out for your administrators and your employees. So my takeaway for you is, employees, no matter what role you serve, if you are an employee of a youth service organization, you shall be trained and shall have your criminal background check performed. And I have no problem with the legislature for doing that. Okay, I would have told you that even without AB506. Everybody who wears your name tag, regardless of what type of capacity, should undergo a background check, receive the training, and understand what are the policies and procedures if and when they did have interaction with children. So quickly moving away from the background checks into the policies and procedures requirement. Now, when I first read this, thought, well, this will at least be the section of the legislation that nobody will have a problem with because it's talking essentially about a 2-adult rule, all right? But it's amazing how many people have had challenges with this that I wouldn't have anticipated. So once again, at 30,000 feet, even without AB506, you should already have policies and procedures in place. Now, when I say policies and procedures, I know that means different things to different people. Here's what I mean by policies and procedures. Policies and procedures provide a written framework. In other words, they're written down. Someone says, well, we have policies. Yes, we have a zero tolerance policy. That is not policies and procedures, right? Policies and procedures are written down, and they're going to describe, consistent with the type of program and facilities, what is and is not permissible within the program related to sexual abuse risk or other types of risk. But I'm focused specifically on child sexual abuse risk, which is what I think is the focus of AB 506, though it will cover physical abuse, emotional abuse, verbal abuse, and neglect, all right? So we should already have policies and procedures because that's already a part of your standard of care. But see, when we get down into the specific requirements, what I'm looking for in policies and procedures, and if you wanted a sample policy and procedure of what I mean by policies and procedures, simply just reach out to a representative at CCIA or reach out to one of my staff members, and I'm happy to give you a form with some color-coded prompts to help you take an 85 on your paper and make it a 95. But it's going to cover the 2-adult rule. It's going to require training of those adults so that we always have 2 trained adults. It's going to involve what grooming might look like in that particular program, knowing that grooming looks different in youth sport than it does in a daycare, than it does in a children's ministry, than it does in education, okay? And if you just heard me say that and you're just like, what? Grooming? You probably haven't heard other things that we've done before. It's important to point out the risk of child sexual abuse does not relate to the abduction offender. The risk of child sexual abuse is the preferential offender and peer-to-peer sexual abuse. So if you've never heard the term peer-to-peer or preferential offender or grooming process of the preferential offender, that sexual abuse awareness training link that I'm going to send to you, you need to curl up and you need to watch that and start to understand what is sexual abuse risk, because then and only then would you understand policies and procedures need to deal with what is and is not appropriate behavior with an understanding first of what the grooming process might look like in that particular program. It's going to involve trusted time alone, electronic communication and social media, communication and reporting processes. So your policies and procedures should cover lots of things already, standard of care. So what does AB 506 do? Because AB 506 doesn't say have policies and procedures that cover all of these things. It's almost like we're fixated on one particular aspect of the policies and procedures. And here's how that reads, just so you know. A youth service organization shall develop and implement policies that cover these 2 things. Number 1, ensure the reporting of information outside the organization. Number 2, make sure that you have at least 2 mandated reporters present to the greatest extent possible. It's probably easier to read this looking at number 2 first, then number 1. Okay? So you shall have policies that to the greatest extent possible, you're going to have 2 people in that program or in that activity related to children. Okay? But it doesn't say just 2 adults. It says 2 mandated reporters. Okay? It's like, let's stop. Get up to 30,000 feet. What I want you to understand is I think what the legislature is looking at is when they had this situation involving Boy Scouts of America, we have a sexual abuse crisis. Okay, we want to write some legislation and have it passed to ensure that this particular crisis never happens again. So it's instructive to kind of deconstruct the crisis they have their eye on to understand what are they trying to accomplish in this piece of legislation. So clearly, some of the difficulties that they're viewing is a lot of this abuse in that Boy Scouts situation occurred because people didn't have training. They didn't have eyes to see, ears to hear, and that led to no mouth that speaks. So the thing we want to do first is we want to make sure everybody receives training so everybody now has eyes open to see abusive behavior and circumstances. So now you can read between the lines. They want to make sure that they have at least 2 trained people. Now, how did they accomplish that? AB 506 doesn't add anybody to the list of mandated reporters. Okay, but what's unique about the people on the list of mandated reporters? Okay, well, there's certain professions, yeah, but what these people on this list are required to do is complete a training to have the eyes to see and understand the requirements of their mouth to speak. Essentially, you're not adding anyone to the mandated reporter list, but you kind of are, okay? Because now all of your folks that count as your 2 adults need to have had what people that are mandated reporters have that the rank and file people don't. And what distinguishes them is not this person going and getting a nursing degree or a teaching certificate, which would ultimately make them someone on that list. What makes somebody unique on that list is they've received the training to understand this is what I need to see and this is my response to it once I see it. So my response to folks saying, well, at my church, Mrs. Clark and Mrs. Smith, they're not otherwise on that list of mandated reporters. Are you telling me that Mrs. Clark and Mrs. Smith no longer can supervise the second grade Sunday school class because they're not on that list of mandated reporters? Okay, I don't think that was the intent of the legislation. So until someone clarifies it, the advice that I'm giving is, as long as Mrs. Clark and Mrs. Smith are people that are trained consistent with paragraph A on that DSS training, or a one that provides the sexual abuse and other forms of abuse and California reporting requirements and processes, then essentially Mrs. Clark and Mrs. Smith are equipped in the same way that somebody that is a mandated reporter is equipped. And then the next piece of that policy, which actually precedes it, is you must have policies to ensure that information gets communicated outside the organization. So it's telling you that people will need to receive the training in paragraph A. Then we need to make sure there's at least 2 of them to the greatest extent possible, and that these people understand that information has to be, by policy, communicated. So what you didn't accomplish by having all of your people made mandated reporters, you accomplished through this policy provision. So my takeaway in this is, you should already have policy provisions that include ways in which we don't have trusted time alone with a child. Okay? We need to have multiple sets of eyes. What this is doing is saying, make sure your people understand what they need to see, and make sure they understand that information has to leave the organization so it doesn't just keep the toothpaste in the tube. And so frankly, I think it's a real complicated way to get to the right place, but I don't disagree with the fact that all of those things are valuable. All of your people need to be trained. All of your people need to have policies and procedures, and your policies and procedures should have the requirements that there be a way in which no child is left alone in trusted time alone with an adult or other child unsupervised, and that information have a process to be communicated outside the organization. Okay? So this is actually easy to fulfill, but a lot of people are getting tripped up on this requirement for mandated reporters as a policy provision. So I already have policies in place. I would tell you, so the questions that I'm getting are unusual. Should I replace my volunteers with mandated reporters? Tell you no. Train your people, create the requirements that now they're essentially de facto acting consistent with someone who is a mandated reporter until we get more clarification from the law. People ask me, well, what if I can't arrange for 2 adults? Tell you, we didn't need AB506 to tell you need 2 adults. This is standard of care already. I would tell you, if you do everything you can and you can't get 2 adults, you need to really strongly consider closing your program. Okay? This is that important as a way in which we ramp down the risk of child sexual abuse. Now, I know somebody's going to call me and say, well, Greg, you don't understand my program. But I'm here to tell you, 2 adult rule is an important foundational functional rule to make sure that children are safe. Last remark on this is, your teenagers do not count as one of your adults. Okay? I know a lot of organizations will use that 17-year-old or 16-year-old, at VBS and expect that person counts as your leadership or counts toward your ratio. I'm telling you, teenagers do not count as one of your 2 adults. All right. Last piece talks about insurance and compliance. I'm going to leave that alone, but I did want to finish with this comment. Sexual abuse risk is getting more and more difficult to navigate. These legislative efforts will continue, and they're going to not be perfect. So as sexual abuse issues demand careful navigation, who you choose to navigate that is a critical piece of your adventure. Not everybody needs a sexual abuse lawyer, but I'm here to tell you, choose a good broker. Okay? Choose somebody, not just a good carrier that writes good products that are gloves that fit your hand. Folks at CCI, good folks that understand this risk. Clearly, they prioritized being able to communicate information to you. This is not a brother-in-law adventure. Make sure that you have somebody walking this path with you that understands this risk, understands risk management, understands when laws are being changed, and challenges to how we can apply those laws so that we're always consistent with standards of care. So again, for more information, ccia.com/AB506. Go to ministrysafe.com/AB506. Lots of information is available. I'm sure there will be a part 3 soon as we continue to have more questions that arise. Don't forget, April is Child Abuse Prevention Month. You can get the parent training for free from Ministry Safe or Abuse Prevention Systems. You can follow any of the links on our site to get access to that. landing the plane. Julie, back to you.
Thank you so much, Gregory. All right, before we go, just a final reminder that we will send out the webinar recording and the training that Gregory mentioned to your emails. And like I mentioned, you can reach out to us directly with any questions that you have. You can email me, julie@ccia.com. And also lastly, church and casualty customers get 50% off Ministry Safe annual membership fees. So we encourage our customers to take advantage of this. You can sign up with your account manager, or you can email myself directly, julie@ccia.com, and we'll make sure you get all signed up. So that concludes our presentation for today. Thank you again for being with us, and we will see you next time.